Hi, I'm Brad. I'm here to talk about fair dealing. Now, fair dealing is the most commonly used aspect of the Canadian Copyright Act in educational settings when it comes to using protected works without the permission of the copyright owner. And while universities and colleges typically provide fair dealing guidelines, like this one, to help users interpret this legal principle into more concrete terms, it can be helpful to understand the concepts and principles that inform these fair dealing guidelines. Now, fair dealing essentially allows for certain acts that would otherwise be copyright infringement to be done without the permission of the copyright owner. As the name implies, the act of copying or use of the work, the dealing, must be judged to be fair. And it's an attempt to balance the rights of creators with the rights of users in such a way that the act as a whole serves the public interest. While fair dealing is the most significant limitation of the exclusive rights granted to copyright owners in the Copyright Act, the Act itself actually has very little to say about fair dealing. The fair dealing section in the Copyright Act contains less than 150 words, many of them conjunctions and articles. And while the Act has established a general principle that limits the exclusive rights of copyright holders, it has been up to the courts to interpret and apply this principle in specific cases. Now, one area the Act does provide clear criteria for is what purposes a user may have when appealing to fair dealing. The Act outlines 8 such purposes, those being education, research, private study, criticism, review, satire, parody, and news reporting. And in the cases of criticism, review, and news reporting, the Act also specifically requires a full attribution of the source. That's it. That's all the Act has to say about fair dealing. Have one of those 8 purposes, attribute for 3 of those purposes, and make sure it's fair. Then you don't need to ask the copyright owner for permission. Of course, this leaves the question of what is fair. And that's where the courts come in. Ultimately, only a federal court judge, or Supreme Court in the case of an appeal, can declare an act unfair or infringing. However, existing case law does provide us with some helpful and significant guidance to avoid ending up in front of a federal court judge. Both Parliament in crafting the Copyright Act and the courts in writing case law have been careful to avoid establishing bright line rules. This is because what is fair should be determined by the facts of the case, and what is fair in one set of circumstances may not be fair in another set of circumstances. In 2004, the Supreme Court of Canada released their decision in what is known as the CCH case, and it included a framework to help us think through fairness. In addition to meeting one of the purposes enumerated in the Act, the court indicated that the character of the dealing could be relevant to judging fairness. That is, how are the copies actually being used? For example, distribution to a large audience is less likely to be considered fair than a single copy made for a single person or a small audience. If the copies are destroyed after serving their purpose, that could also favor a finding of fairness. The court suggested that common practice in an industry or trade could be a guide, with acts that go beyond standard practice possibly less likely to be fair. When it comes to the amount of the dealing, the court was clear that while total quantity in both terms of number of copies and portion of the original should be considered, the fairness of the amount will be relative to the purpose of the copying. For example, it might be impossible to accomplish the purpose without copying an entire poem for the purpose of criticism, for example, or an entire research article for the purpose of private study. The copying should be no more than is required to accomplish the purpose of the dealing. And so factor-like amount should be considered, but there's no clear quantitative measure that will apply to all situations. Alternatives to the dealing might be a relevant consideration as well. Was there a way to accomplish the goals of the user without making a copy? For example, was a non-copyright protected equivalent to the work available? The nature of the work might also be a consideration. Copying an unpublished or confidential work may be less fair than doing the same with a published work or work intended for public distribution. And finally, the effect of the dealing on the original work will be considered in most cases. If copies or distribution competes with the market for the original work, it's less likely the dealing will be considered fair. And so this framework sets out some of the kinds of things a court might consider, though a court may well consider other factors as well if they're deemed to be relevant to the case. Beyond the list of specific purposes in the Act, a court will not look at any one of these factors as determinative, but will assess all of them taken together on the whole. So hopefully you can now appreciate that fair dealing leaves a lot of room for subjective judgment. Bright line rules might simplify things, but the goal of copyright is a balance between the rights of copyright holders and users to the end of serving public interest. And so this kind of subjective fairness standard is appropriate in the approach that the Parliament and the courts have tried to take. We want each dealing to be fair on its own terms. So the application of fair dealing to real situations, anyone familiar with the court's framework and the Act is capable of evaluating the fairness of an act that they're considering undertaking. However, consulting with someone familiar with the Copyright Act, relevant case law, and also practiced at assessing fairness and familiar with standard practices across the post-secondary sector in Canada can be helpful as you navigate fair dealing in your own teaching and research. Thanks.